Hello everyone, my name is Nkem Violet Oche. I'm a PhD student at the Law School Robert Gordon University, United Kingdom. The title of my paper presentation is the Impact of Multinational Oil Companies' Level of Engagement with Human Rights Obligation in Human Rights Litigation in the Niger Delta. The outline of this presentation is as follows. I will first introduce the paper, then I will talk about the human rights obligations of Shell and the multinational oil companies' levels of engagement with their human rights obligation, and the importance of human rights litigation arising from the Niger Delta. After that, I will discuss my finding and make my concluding remarks. I would like to start by saying that the way multinational oil companies handle issues and complaints vary and can demonstrate the level of engagement with their human rights and environmental obligation. This level of engagement could be inactive, reactive, active, and proactive level of engagement. Now, the lack of appropriate level of engagement is the reason for recurring conflicts and incidents of human rights and environmental violation in the Niger Delta, which in turn have led to numerous transnational human rights litigation in the Niger Delta. Now, human rights obligations are policies a company develops or sign on to indicate what the company intends to do to address its human rights and environmental programs. These obligations covers a wide range of aspects including transparency and disclosure of evidence that could be required by the plaintiff, safety and security, prevention of oil spill, cleanup, and compensation. Now, this paper considers Shell as a case study to illustrate the relevance of human rights and environmental obligation. Shell human rights obligations are contained in several sources, such as its official website, policy, manuals, reports, public statements, code of conduct, Shell sustainability reports. For example, one of Shell human rights obligations is stated as follows. Shell is committed in respecting human rights as set out in the United Nations Universal Declaration of Human Rights and the International Labour Organization Declaration on Fundamental Principles and Rights at Work. Let us be very clear about the legal importance of human rights obligation of the multinational oil companies, which is usually taken lightly. For example, Shell filed an incorrect information with the United States Security and Exchange Commission, and as a result, they had to settle a fraud case with the SEC in 2004 for overstatement of billions of barrels of proved oil reserved, in violation of their Security and Exchange Act 1937. So let us summarize the three transnational human rights and environmental litigation, and we'll start with River and Shell. In this litigation, the plaintiff sued to hold Shell liable for complicity in the wrongful arrest, detention, and execution of 9 environmental activists in 1995 by the Nigerian military. There were two main issues for determination. The first was whether the court could exercise personal jurisdiction over the defendants, Shell and XPDC, and two, whether the human rights abuses in the litigation fell within the scope of the authority of the federal court based on the Aliens Act. So the Court of Appeal ruled that the U.S. court would exercise both personal jurisdiction and forum non-convenience over the defendants on several grounds, including that Shell was doing business in New York and the trial would be expensive and inconvenient to the plaintiff if heard outside the United States. So before the trial, on June 8, 2009, Shell settled the case out of court with a sum of $15.5 million. In the case of Bodo and Shell litigation, a group of Nigerian farmers and fishermen filed a lawsuit against Shell and Expedition for 2 oil spills in Bodo community. The two main issues of determinations are whether the claimants are only entitled to claim compensation in respect of the 2008 spill under the Oil Pipeline Act, and 2, whether XPDC could be held liable for oil spill due to sabotage rather than faulty maintenance under the Nigerian law. The court ruled that there is no liability for oil spill caused by sabotage under the Nigerian law, but the liability could exist due to neglect in protection of the oil pipeline. Few months before the trial was set to proceed, based on the evidence produced, Shell settled the litigation out of court, and about $55 million was paid to the victims. Also in Oguru and Shell, 4 Nigerian farmers and the Dutch NGO filed a claim against the Royal Dutch and Expedition for failure to exercise due care to prevent oil spill and clean up contaminated sites. And the issues for determinations are whether the Dutch court could assume jurisdiction over the claims against the Nigerian subsidiary, also whether the oil spill had been caused by faulty maintenance or by sabotage, and whether Royal Dutch Shell owes a duty of care to claimants for harm caused by the SPDC. In the most recent decision in January 2021, the court ruled that the Royal Dutch Shell owed a duty of care to the claimant and is liable to pay compensation and cleanup due to failure to prevent oil spill. Also, Shell was ordered to install leak detection equipment in its pipeline. So let us explain the different multinational oil companies' levels of engagement with their human rights obligation. In the inactive level of engagement, the company approaches the litigation by being defensive and calculating on how to kill the case. In the reactive level of engagement, the company approaches the litigation by being defensive and calculating on how to minimize the risk if they cannot get away with the allegation. In the active level of engagement, the company approaches the litigation to resolve the dispute. Also, in the proactive level of engagement, the company approaches the litigation to resolve the dispute and also to contribute to future complaints. An example of the reactive level of engagement is when the company bluntly refuses to disclose evidence but will do so only if it's unavoidable due to legal obligation or pressure from the investors or government. A proactive level of engagement is when company discloses evidence and also puts in place a mechanism to provide evidence in future. So an evaluation of the level of engagement against the 3 litigations shows that there is no evidence that Shell proactively shaped and implemented its human rights obligation. So in Wiwa and Shell litigation, Shell was inactive in its approach because it was defensive and calculating on how to kill the allegation. Also in Bodo and Shell and Oguru and Shell litigation, Shell was initially inactive at first, but later it was reactive in its approach in order to minimize the risk. And they do this only if it's unavoidable. For example, Shell only accepted to pay compensation and clean up the oil spill when evidence emerged in court during litigation that it was warned of its faulty oil pipeline but failed to take actions. So aspect of Shell's inactive and reactive approach of human rights litigation. Shell was inactive and reactive in its approach in several ways, including lack of transparency, non-disclosure of evidence, poor safety and security, prevention of oil spill, delay of litigation, inadequate cleanup and non-payment of compensation. So I would like to discuss a few aspects of Shell inactive and reactive approach to engaging with their human rights obligation. Shell used several techniques to postpone the litigation initiated against them. In Wiwa and Shell filed a motion to dismiss the case on the ground of lack of jurisdiction. In the case of Oguru and Shell challenged the standing of the individual claimant and joint claimant, which delayed the case from being heard. Shell also sought to postpone the proceeding pending the outcome of related litigation in another court. Also, Shell also demonstrated lack of transparency in the oil spill data provided and also refused to disclose crucial evidential documents. In the case of Oguru and Shell litigation, the judge had to intervene by ordering Shell to bring the document to the court for analysis by the plaintiff to prove what Shell knew about the condition of the oil pipeline and in its internal operational practices. During the Oguru and Shell litigation, the plaintiff lawyer traveled to Nigeria to interview some of these witnesses about the oil spill data, but found it very difficult due to the pressure and intimidation by Shell. Many of these experts worked for Shell and were unable and unwilling to testify against the company. And also, prevention of oil spill. The multinational oil company always attributes the cause of oil spill to sabotage because under the Nigerian law, oil spill caused as a result of sabotage, the company won't be held liable and the victims won't be compensated. Also, Shell also frequently dispute information related to the cause of the oil spill, the volume of the oil spill, and also area affected by the oil spill. For example, in Bodo and Shell litigation, Shell only accepted to pay compensation and cleanup of oil spill when evidence emerged in court during litigation that they were warned of the faulty pipeline, but they failed to take action. And this is an example of reactive approach. So let us explain how multinational oil companies with a proactive approach improve human rights and environmental protection. In 2006, the Nigerian government commissioned the United Nations Environmental Programme to conduct environmental assessment in Ogoniland. Shell was proactive in its involvement as they were part of the independent assessment, and also they accepted to fund the assessment and provided data as requested. Shell also agreed in advance to accept the findings and recommendations of the report. So after the report was concluded, Shell established an independent committee to review its practices on remediation of the oil spill and has since commenced a comprehensive cleanup and restoration of contaminated sites in Ogoniland. So the findings of this report have been referenced in several human rights litigation against Shell. So in conclusion, the impact of multinational oil companies' level of engagement with their human rights obligation during litigation arising from the Niger Delta has been discussed. A proactive level of engagement is recommended to improve human rights and the environment in the Niger Delta. These are my list of cases and references. Thank you. And I'll be happy to answer any questions.